So Roe versus Wade, the leaked Dobbs opinion reminds me of Bowers versus Hardwick. You remember that case?
Mm-hmm. Yeah.
Where the court chose to focus on something that is patently silly, right? So they spend time in Bowers versus Hardwick, which was the first challenge to sodomy statutes, talking about whether or not they can find a historical right to homosexual sodomy in our nation's history. And oh, shockingly, they can't find that. This Dobbs opinion is doing the same thing, right? Can we look back and find a historical right to abortion? No, we can't. Well, why can't you? Women couldn't even own property, Shawn.
Mm-hmm.
Of course there was no a historically deep-seated root of a woman to control the circumstances of her body in our history. Of course there wasn't.
Mm-hmm.
Just like, of course, there wasn't that right to homosexual sodomy in Bowers versus Hardwick. There was far too much discrimination and gay animus back then. So of course there wasn't.
Welcome to Deep Dive with me, Shawn Fettig. I'm a political scientist, and I'm interested in trust, how our governments and politicians can gain our trust and how they lose it, but also how our personal stories can build trust and bind us together. So this space is dedicated to diving deeper into issues that are interesting, at least to me and hopefully to you, and that maybe we aren't always sure how to talk about. Welcome to premiere week of my new podcast. This week you're getting 2 episodes, one today and one Friday. But don't get used to it. After this week, a new episode will become available each Friday morning on all major podcast platforms. And that includes, but it's not limited to, Apple Podcasts, Spotify, Google Podcasts, Amazon Music, iHeartRadio, Stitcher, Pandora, etc., etc., etc. And it'll also be available on podcast apps, including Overcast, Castro, Castbox, and Podfriend. In this premiere episode, I'm talking to a buddy of mine, Dr. Sara Benesh. I've invited Sara to speak today because she's an expert on trust in and legitimacy of the judiciary, the courts. She's the chair of the political science department at the University of Wisconsin-Milwaukee, and she's published a wealth of original research on the judiciary and its legitimacy. Her work has inspired mine, including my dissertation project. It's especially relevant timing for us to reconnect now and chat about the state of the United States courts today, particularly the Supreme Court. Our conversation is wide-ranging, but we touch on the court's legitimacy, of course, how to measure it, if some enduring support for the institution exists, and if not, why not. And we also talk about the leaked Dobbs draft opinion that suggests the court will be overturning the Roe v. Wade precedent in the next few weeks, and what that might mean for the legal and constitutional landscape of our country, as well as what it might portend for other rights that have been codified using similar reasoning. And in the end, you can decide for yourself who you agree with when I suggest to Dr. Benesh that the Supreme Court might be bringing the country to its knees. Dr. Benesh, welcome. Thanks for being here. How are you?
I'm great. How are you, Shawn?
I'm great as well. I'm even more great because I'm chatting with you now.
Oh, well, obviously.
Yeah. So, I may have already told you this because I think I wear my heart on my sleeve a bit, which isn't always necessarily a great thing. But you are a large reason that I pursued my doctorate, and specifically in political science, and even more specifically with a focus on the judiciary. Did you know that?
I mean, that's awesome to hear.
But it's new information, right?
And I'm super proud of you. No, I don't know. I mean, you wear your heart on your sleeve to some degree, but I don't know if you ever told me that I meant anything to you. So thanks.
Also, another fun fact. So as I was prepping for this, I realized we've known each other for about 20 years.
Oh my God, that's ridiculous.
You were one of my professors in my first semester at university. And then I guess to bookend my academic career, you were also my dissertation advisor.
Wow. So you started at UWM the same year I came then, probably.
Yep, I did.
Oh, interesting.
Yeah. And we've worked on a couple of projects together, primarily focusing on the Supreme Court and judicial legitimacy, which is why I wanted to talk to you today.
Yeah. Let's figure it out.
Yeah, let's, because we have not. So specific to the court, when we talk about things like legitimacy, what is it and why does it matter?
Oh gosh. I mean, the question of what is it, I think, is a really tough question to sort of verbalize. I think, we all sort of had to have this idea in our head of what a legitimate institution is. And that usually kind of coalesces around ideas that an institution has the right to make the decisions that it makes, that it ought to be afforded power in society, that we should listen to the edicts that come out of the institution, sort of that it has a right to exist and plays an important role in democracy. And I think that's, maybe not super controversial that, we need to have a certain level of legitimacy toward our governmental institutions in order for our government to function. But I think it gets really dicey when we start to think about how we might operationalize that. So as political scientists, we're always trying to find ways to measure concepts. How do you measure a concept like trust, or, for lack of a better word, just legitimacy, I guess, trying to think about how do you measure that kind of commitment to an institution as an important part of a governmental structure. And so we try to come up with ways to ask questions on surveys that tap into this underlying concept of legitimacy. And, we sort of fail spectacularly every time we try to do it for different reasons. So some measures are bad for one reason and other measures are bad for a different reason. And I would argue that we really don't have a strong handle on what it actually means for an institution to be legitimate.
In like legitimacy literature, we tend to approach this from two directions, right? Or at least from two perspectives. And that's a difference between long-term legitimacy and short-term legitimacy. Long-term is something that we call diffuse support, and short-term is specific support. Can you explain the difference? And then, in your experience, is one easier to measure than the other?
Yeah, I think the specific support piece is the easy piece, right? So whenever we ask the public, do you approve of the job that the president's doing? How warm do you feel toward the Congress? All those kinds of questions tap into people's basic agreement with the things that people in government are doing. And that tends to tap into this idea of specific support. So if we ask, do you approve of the Supreme Court? Do you like the decisions that the court made? Those kinds of questions are all, sort of short-term policy agreement kinds of questions. And they may or may not be related to legitimacy, which is that, nebulous concept I was trying to articulate at the beginning. So some of the big debates in the literature are explicitly about that. So do those policy inclinations or agreements or disagreements, do those matter to a person's deep-seated trust and, sort of support for an institution as an institution in government, which is more of that diffuse support kind of idea. And so I think a lot of the newer literature is really finding that it matters a lot whether or not you agree with the outputs of the institution as to how legitimate you deem that institution to be, whether we measure legitimacy as, support for court curbing kinds of activities like limiting jurisdiction or putting a cap on the number of years that a justice can serve, or if we measure it in that really big way of saying, if the court started making a lot of decisions that we disagreed with, we ought to just do away with the court altogether. All of those things are filtered through that kind of policy agreement. And I think that's new-ish. So when we started this work a long time ago, that was just starting to be a question over whether or not that mattered. There was this idea that an institution built up legitimacy over time through pleasing rulings, but that legitimacy is for losers, right? That we want people to feel like even when they lose, the institution had the right to make the decision. And so there was just a start of a discussion about whether or not policy preferences might enter into that calculus. And we thought that they really didn't, that diffuse support was something more enduring, more deep-seated, more heartfelt, more, intrinsic to the democracy. But now I think because of polarization, everything's just going to be about party now. And it's really sort of getting ugly.
Yeah. And so you're touching on something that I've been thinking a lot about lately within the realm of like long-term legitimacy. And this is something that you and I researched together. And we tried to kind of parse out the difference between short-term legitimacy and long-term legitimacy, or diffuse support and specific support. And I've been wondering as well, with long-term legitimacy or diffuse support being rooted more in institutions and its norms and practices, how it sits in a democratic structure, respect for stare decisis or precedent, and that it endures, this legitimacy endures irrespective of the ideology of the current justices, right? The court is not political, that the court is not driven, or its decisions anyway, aren't driven by personal ideology, that the rule of law is supreme, that all sides are kind of given some type of consideration. And as you kind of suggested, it does seem, and I'll reframe that these underlying values seem to be under attack. And the public seems to have caught on to this reality that the court will issue opinions based on the majority ideology of the currently seated justices. And to me, this makes the court very political. And some examples of, what have contributed to that might be like the refusal to even consider Garland when a vacancy opened under a Democrat president, or the fact that the court is increasingly relying on its shadow docket, which is, in a nutshell, the issuing of opinions in darkness and without explanation or public debate. And then and I want to touch on this a bit later, but it seems to be, on the horizon is the very quick overturning of super precedent with Roe when a majority of conservatives are on the bench, regardless of overwhelming popular opinion against it. So I've been wondering, and I'd actually be willing to suggest, and I want to hear your opinion, your thoughts on this, that this diffuse support, long-term legitimacy might not actually exist if it ever did at all.
Well, I have a few propositions for you about other things that don't exist too, like constitutional law or
Wow.
Yeah, but I mean, I disagree with you. I think that institutional diffuse support does exist. I think the issue is, again, I think it's polarization. So I think because of the way that Republicans have placed the judiciary on its policy agenda and have for, 20, 30 years, focused their attention on judgeships in a way that the Democrats never thought about doing. Mm-hmm. Because they have done that and politicized that part of the process, they have gotten what they sought, which are justices and judges who have a very conservative bent to the law or to their rulings. And that has caused people who disagree with them to be upset. And I think all of that has, filtered through increased polarization and increased separation to create sort of this perfect storm where, like, even if I do feel really strongly that we need an independent judiciary to provide a check on the other branches of government, what I really want abortion to be illegal, or I really want to get rid of these precedents that allowed for gay marriage. Mm-hmm. So I think it's becoming there's a point at which people have abandoned maybe or placed less emphasis on abstract democratic ideals and values in the furtherance of these sort of winner-take-all kinds of setups where winning at all costs is what we're going to do. And so I think that makes it feel like diffuse support doesn't exist. When really it exists, but it's sort of been implicitly backseated by people who are more interested in policy preferences.
So the Republican Party has taken this, and this is what you mentioned, right? Like over the past couple of decades, a singular kind of focus on reshaping the judiciary. And the underlying understanding here is that they understand that the ideology of the justices does matter. Do you think we can extend that to say, that means that the ideology of conservative justices and the ideology of liberal justices matter? Or do you think somehow Democrats missed the boat and actually liberal, quote unquote, liberal justices actually do have more respect for kind of stare decisis or precedent or legal theory, and that conservative justices do not?
No. I mean, I think that's what I mentioned in passing earlier, that common law doesn't exist. I think both sides do this, and I think they have been forever. And I think it started in, the Warren Court, which was far more interested in getting actively involved in policymaking than courts before it had. It was positioned in a way that was possible, given legitimacy and given the role of the court in society and the preferences of the public and all those kinds of things. But I think that, that was a liberal court that was engaging in I don't know, for lack of a better word. I mean, I just recently was telling someone, I can't remember who it was, that was sitting in my office that the more I read and the more I consider different areas of law and different kinds of constitutional law and different court opinions, the more I'm convinced that this is all absolutely made up. And so if that is true, that this is all absolutely made up, then it's always been about the preferences of the judges and the justices. And so there's nothing new in that regard. But you're right that there was a recognition at an early time, probably due to backlash against the Warren Court, that, if we could have a court that was engaging in this activism in a liberal direction, we might also be able to do that same thing in a conservative direction. So let's build that, right? And I don't think Democrats lacked that understanding, but I think they took for granted the idea that the court was an institution aimed at protecting minority interests, without recognizing that the reason the Warren Court was aimed at that was because that's what they wanted to do.
I'm actually a bit excited, to be honest, that you say like maybe all of this is made up, right? I remember standing in front of students and really parsing out with them, well, what if this norm falls? And then the response would be like, well, then there's this other thing that's a backstop. Well, that's a norm too. What if that falls, right?
Mm-hmm.
And then eventually we get to the beginning of time and everything is built on, I don't want to say a house of cards, but I mean, could be conceptualized that way. Mm-hmm. So when we talk about court decisions, okay, I understand what you're talking about. But when you say everything, what are some other things you're talking about?
That everything is made up.
Yeah.
What do you? I don't know. What do you think I'm talking about? What are you aiming at here?
Our entire constitutional structure.
Well, yeah, that was obviously made up, right? I mean, that was those framer guys, and they were standing around thinking about stuff and putting things in words that we pretend we can understand and understand the motivations for, but we don't know, right?
But there's a reality that people make very illustrious careers out of explaining, how important this is and how thoughtful this all was. And I think that this was also people, maybe, I don't even want to say they were doing the best they could, but they were cobbling together concepts and theories that were in response to very specific things and events that could be reconstituted, cobbled together in some other configuration that spits out a completely different structure that still maybe meets the needs of the time.
Yeah. Yeah. I mean, I think the framers were super smart. And I think that as a group of people, far more thoughtful than anybody who's serving in our Congress today. Mm-hmm. But they were also products of their time and their biases and the realities that they faced and the lack of information they had about the future. And so, of course, they did the best. I think they did the best they could do under all their constraints and probably with respect to, all of the decisions that they had to haggle over, right? There were all kinds of, concessions made and those sorts of things. But I think they did a pretty great job. I mean, we have in many ways, a very stable and accomplished government, but, they didn't have any sort of magical powers. And I don't think looking back on what the decisions that they made were at that time, given their character and construction and in reality, I don't think there's any reason to give those any sort of outsized influence when we're trying to understand how to resolve really difficult policy questions in the U.S.
In that sandbox of solving difficult policy questions today, with this leaked decision in Dobbs suggesting that the court's going to overturn Roe, that has led to a lot of legal gymnastics as to, okay, well, does this mean that some other things might be, at risk? Things like contraception, interracial marriage, same-sex marriage, and, some folks say, yes. Do we actually believe, in the vein of this conversation, do we actually believe that if the court wanted to, if they got 5 justices that wanted to strike something like same-sex marriage or interracial marriage, that would be a barrier to them?
Do we actually believe that? That what would be a barrier?
The constitutional reasoning for establishing, the right to same-sex marriage actually has, more of a foundation than does something like Roe v. Wade.
No.
Exactly.
No. I mean, the fact that there's a leaked opinion that completely overturns Roe versus Wade is exactly the answer to your question, right? I mean, there was a time when I think many of us thought, and I was definitely in that group, that, the court will not overturn Roe. It might continue to accept limitations on, women's healthcare decisions, but it won't completely undo that precedent. It's too old. It's too strongly relied upon. It's, whatever. But that draft just belies that argument. The fact that Alito can write whatever that is, 90-page, I guess a lot of it is just old abortion laws, but the fact that he can write an opinion, oh gosh, where do I start on this stuff? Again, it's all
Here's
made
an edit point.
it's all made up. No, I think so. So Roe versus Wade, the Dobbs, the leaked Dobbs opinion reminds me of Bowers versus Hardwick. You remember that case?
Mm-hmm. Yeah.
Where the court chose to focus on something that is patently silly, right? So they spend time in Bowers versus Hardwick, which was the first challenge to sodomy statutes, talking about whether or not they can find a historical right to homosexual sodomy in our nation's history. And shockingly, they can't find that. This Dobbs opinion is doing the same thing, right? Can we look back and find a historical right to abortion? No, we can't. Well, why can't you? Women couldn't even own property, Shawn. Mm-hmm. Of course there was no a historically deep-seated root of a woman to control the circumstances of her body in our history. Of course there wasn't. Mm-hmm. Just like, of course there wasn't that right to homosexual sodomy in Bowers versus Hardwick. There was far too much discrimination and gay animus back then. So of course there wasn't. So when they changed in Lawrence to the question of whether or not there was a protected fundamental right to sexual intimacy, there we find a right? We have expectations as heterosexual and homosexual people that what we do in a consenting way with another adult in our bedroom is something that is off limits to the state, right? We have that same expectation with bodily integrity. And had they instead in Roe rested on bodily integrity and really focused on that from like the Cruzan case and from the torts that existed at the time that said you can't force someone to have a surgery or a blood transfusion or whatever, maybe that would have been more solid ground. But again, that is playing in a I guess, what did you call it, a sandbox, where there's actual real constraints on these decisions that these justices make, And so, yeah, you're right. You're exactly right. What I did immediately upon reading the draft opinion was write down all the ways in which if the court had relied on a right to bodily integrity, the court would have decided differently. I was engaging in, as you called it, legal gymnastics. And then I put my pen down and I was like, none of this matters, because if they want to see it this way, this is the way they're going to see it.
I check out of these debates, to be completely honest with you. When people try to explain to me, no, right? Like the decisions that, established the right to interracial marriage and same-sex marriage, those hinged on different mechanisms. And there were different, pieces of the Constitution that stand on some more solid ground. And to be completely honest with you, bullshit, right?
I think that, so somebody else, I was on a call-in show or something, and somebody asked about racially integrated marriages. And I do think that is something that there would be no going back from, right? The Loving decision is based both on the fundamental right to marry, which the court said in that case is a fundamental civil right of man, and, the really strong protections that we've enacted after slavery for racial discrimination. And that is, obviously a racially discriminatory decision to not allow a white person and a black person to marry. It obviously doesn't meet strict scrutiny. Again, yes, that's all made up stuff, right? Strict scrutiny is something the court just used to decide how to interpret the 14th Amendment's Equal Protection Clause with suspect classifications. They could change that. But that is really fundamental, right? Gay marriage is different because every time the court has considered differences or discrimination on the basis of sexual orientation, it has only required a rational basis for that discrimination. And, ideas about morality have been things that they have held up as rational. And so I think the gay marriage case is a much harder one.
Let's dig into just the idea of a leak from the court, because There are two specific debates that seem to be playing out when it comes to this leaked opinion. One is the actual leaked opinion, which is what we've been talking about, right? And the substance of it. And the other is how shocking it is that, there was a leak in the first place, right? So why does a leak matter?
I'm not sure. I think it's a really, I mean, first of all, I love trying to figure out this inside baseball of like who leaked this opinion? How did it happen? What did Politico get? Like, was it a printout? It seemed like it was from some forensic PDF kind of things I've been reading. So I think it's super fun to try to figure out who did it and what their motivation was, because the motivation part is really hard to figure out. But beyond that, in terms of like, does it matter? What does it do? That's, I think, really a lot less certain. So, Thomas came out and said, oh, this is terrible for legitimacy of the court. I don't really think that a leak, directly affects the way people feel about the court as an institution. I think people who were happy with the opinion thought the leak was terrible and illegal, which it's not. And people who hated the opinion, there were some people saying it was heroic, I mean, I don't know. I mean, what is the impact of a leaked opinion that's going to be handed down a month later?
Yeah. I have this thought that had the leak happened and it was just like, here's this leaked decision and we're going to focus on the substance of it, there would be no impact on, I suppose the legitimacy of the court. But when we focus on, when the media and I suppose elites focus on the rarity of it, and suggest it will harm the court irreparably, it's that narrative, that framing that might actually be moving the needle on legitimacy.
Well, and I think that, that points to like this whole, difference that we seem to have between the Supreme Court and the other institutions of government, right? I mean, we'd think nothing of a leak coming out of the president's office or a leak coming out of Congress, but we have this myth of, legality, specialness, whatever, about the Supreme Court. So that makes it more notable than it would be under any other circumstance. And so then maybe that does affect legitimacy if we think legitimacy is in some ways impacted by these myths that we hold about the Supreme Court as an institution. So the Gibson talks about the positivity bias, so is it the case that every time we look at something from the court, given the beautiful marble exterior and their robes and the beautiful velvet drapes behind their bench, do we treat things related to the court differently? And do we see them as more impressive and more, worthy of respect and all those kinds of things? And then does a leak affect that facade? And maybe that's where it impacts potentially, depending on how many people still believe that. I've been, in thinking about all these questions about legitimacy and really focusing recently on party polarization, I've read some things that suggest that in a partisan based polarized polity, wow, that was awesome. You have the ability for elites to play an even larger role. Because again, people are always looking for shortcuts, right? For, do I agree with this? Do I not agree with this? When if you're in like the partisan situation we're in, where the parties are so separated and there's no overlap and there's no moderates anymore, then it's really easy to just say, okay, well, I agree with whatever that political elite just said. So, using party as a proxy is even stronger today than it maybe was, back when we used to have moderates.
So you mentioned Clarence Thomas's statements about the leak undermining trust in the court. And to me, this feels a bit like gaslighting, because I'm not sure if he actually believes what he's saying, because I'm absolutely serious,
like
because well, we don't have enough time. But, immediately what comes to mind is things like his refusal to recuse himself from cases related to his wife's work thus far, right, on the Trump insurrection. And I just kind of call it the refusal. As mentioned earlier, the shadow docket and the overturning of decades of precedent and the refusal to seat Gorsuch, like these all feel like actual tangible things that would influence trust in and legitimacy of the court more so than the leak. Do you think he actually believes what he's saying, or are we just crazy?
I don't know if I ever think that Thomas believes what he's saying. I'm not sure.
Does he think we're stupid?
I mean, As a general proposition, I don't think that's wrong. Not about you and me.
Wow.
But yeah, I mean, does he actually think that I mean, I think they do, because so the court, the justices, and especially I think the Chief Justice, really do exhibit indicators that they worry about perceptions of the court. Now, I don't know if those are real, and I don't know if they're telling the truth or whatever, but it seems to be the case that they do think about that at least occasionally. But I think they think about it in a very ceremonial way. So, like, if we can guard our secrecy, if we can be seen as not being political, if we can, just very in a sort of externalized, symbolic sort of way, anything that takes away from that. So you remember when people were talking about, or when I think Trump talked about an Obama judge or something, and Chief Justice was like, no, there are no Obama judges. They're just judges, right? I think whenever that facade is in some way threatened, the justices immediately push back and say, no, that's not the way things happen here. Same thing with about, Maskgate with Sotomayor and,
right.
and Gorsuch and all that kind of stuff. There was this reporting that they were fighting, and they were like, no, we're not fighting. We always get along perfectly. So I think that the justices try to perpetuate the, mythologies that we think people at least used to hold, maybe still hold, about the Supreme Court. And so they do think that anytime that veil is pierced, that's a problem for legitimacy. And so I think, he would see that kind of a leak as, providing some sort of evidence that there's political something, some sort of fighting going on at the court. And so then the justices all feel like they have to say, oh, this is a terrible thing. Because I think they've all said stuff about how, disturbing this is and whatever. So, yeah, I think they believe that they have legitimacy tied to the perception that they're not political. I'm not sure they're entirely appraised of the extent to which people know that they're political, or maybe they haven't admitted to themselves. I don't know.
Yeah, I guess I'm just wondering if Thomas is kind of cherry picking the narrative that he wants to make as to what's influencing legitimacy, and maybe willfully ignoring some of the things that at least also do, right?
Sure. Yeah. I think that's absolutely true.
So a lot of conservative jurists make the argument that the Constitution is a dead document, dead per Scalia, God rest his soul, which means that the words as they're written and meant at the time are supposed to severely limit how judges and justices should and could interpret and apply the law. And we call this originalism. And to me, this has always felt like a convenient excuse to forego like any creativity, intelligence, or rigor in solving contemporary problems and challenges in American society. What are your thoughts about this?
Well, as I mentioned earlier, I don't think that there's any particular reason that we need to hold up the framers as above any other influence on constitutional interpretation, first. Second, as I said, everything's fake. And so I think...
I mean, this is your thing now. This is...
It is my thing. It's my complete and utter desperation with the world. Like nothing's real anymore. Yeah, I think the, purporting to exercise purporting that originalism somehow constrains decision-making so that judges are not using their ideology is preposterous, right? Because we know that when originalist arguments are employed, they're almost always employed specifically toward conservative outcomes. And there's empirical evidence on that. Whether or not it's, what did you ask me about originalism? Like specifically, like, is it stupid?
Well, I mean, that is where I'm going with this. Is like, is originalism, I mean, is it as a theory just stupid? Yeah.
Is it real? Is it stupid?
Yeah.
Yeah. I mean, I think, first of all, they don't do it well, right? So the justices are not historians, it turns out.
Yeah.
And
or consistent.
Right. And so I think in that regard, first of all, it immediately belies the claim that this takes away discretion, right? Because we know that historians disagree about things. Like that's part of their discipline. And the justices aren't historians, and they all use this reasoning to reach conservative outcomes, which is, obviously implausible if we think that this is some sort of real effect on, there's got to be some liberal outcomes, right? And Scalia had some liberal outcomes with his originalism, his brand of originalism, now and then, like with confronting witnesses against a person. But generally speaking, we're talking conservative. So is it a real theory? It's something that, Scalia and Thomas have sort of invented, and then law professors got on the bandwagon for and made, wrote a whole bunch of articles about. And, so is it real? Well, sure, it's real because they created it. Is it anything the framers would have intended? I don't think so.
That's a really good question, because I don't think so either.
Yeah, I think the framers were really specifically careful about making an enduring document that was going to change more easily than the Articles of Confederation, but also with time and our understanding and advances in technology and all those kinds of things. I think that was their reason for so many vague provisions, so much left open for interpretation. I think those things were purposeful. So I doubt that they would think it's really great that we've got justices on the court, increasing numbers of justices on the court who are interested in deciding cases on the basis of what the framers meant when they wrote the words. So, I guess that's kind of a reverse originalism argument.
Maybe that's a new theory.
It's a new theory. We'll write it up.
All right. So to preface my next kind of set of questions, I'm going to set a scene. So in 2008 and then 2010, the Supreme Court ruled in two cases, DC v. Heller and McDonald v. City of Chicago, that limits the state's ability to regulate guns and that individuals had the right to keep and bear arms. And this upended more than 200 years of law and precedents about how guns could be regulated in the United States. And so recently I just did a little bit of research, and based on Mother Jones' tracking of deaths and injuries related to mass shootings, I've got some data. So from that first case in 2008 until today, at least 680 people have been killed and 1,121 have been injured in mass shootings. And that's in 14 years. In contrast, in the 25 years prior, from 82 to 2007, 353 people were killed and 341 were injured in mass shootings. This isn't causation. There's nothing that's being controlled for here, but there is a correlation. And the point I'm trying to make here is that it almost feels like the Supreme Court might be bringing the country to its knees in a way. It's more difficult to swallow this coming from the Supreme Court than when it comes from Congress or the presidency, because these are 9 unelected people that serve for life that are extremely out of step with public opinion on incredibly consequential issues. What are your thoughts on this?
I don't know if you want me to talk about guns right now, given the fact that I'm a mother and...
Well, you don't have to talk about guns. I'm just trying to set the stage for this idea of them making massive, consequential decisions that run counter to public opinion. Roe v. Wade is one, it appears.
Yeah, I think it's hard to, as you said, it's hard to establish causality. It's difficult to understand, there are some who argue that the Supreme Court has no impact, right? So Rosenberg would say that the Supreme Court by itself really can't do anything. And so, to say that the increase in gun violence is somehow part of a consequence of the DC versus Heller case, might get some pushback, although, I think I'm sympathetic to that argument. And an overruling of Roe would obviously have some substantial consequences. I think it's interesting that you use the language of bringing the country to its knees, because I think so I guess the gun case and the Roe case are really leading me in different directions in this. But I think in some ways, what this conservative court has been really engaged in is pushing decisions to the states. So it's more of a federalism promotion than necessarily a policy-based promotion. But I don't think that's true with the gun cases.
With the gun cases, right?
Yeah. But if we look at what they've been up to with Roe and with voting rights and gerrymandering and some of those other instances, they have really been sort of the opinion that many things are better handled at the state level. And obviously that has huge ideological components, right? The original parties were about, does the federal government have power or does the state government have power? That's something that we've perennially debated and separates Democrats and Republicans. But if we just sort of take as a just sort of a truth that what they think about a lot of these issues, especially issues that have been read into the Constitution in their view by prior decisions, so things like this substantive due process, that if it's not specifically stated in the Constitution, we ought to let the people who are governing closer to the populace make these decisions. And so are they putting us to our knees, or are they just shifting where the political action has to happen to the states? I think those are maybe two different things. And then just like a comment on public opinion also, because one of the things that I have been really fixated on is this real lack of representation in government in general. So it's not just the Supreme Court, because, and they're obviously visible offenders, given that it's just 9 unelected justices who served for their entire lives, and they're old, and, for a long time they were white and male only. But, the Senate is a terrible representation.
Yeah.
Also, the president is not a great representation, not an office that's really elected by the people, given the Electoral College. And then all of this gerrymandering has made it impossible for people's voices to really be heard in state government either. So I don't know, is there some sort of crisis of representation in general, and the Supreme Court is just one piece of that? Or is it somehow worse that the Supreme Court is in this position? I don't know. I mean, I think it makes the appointments uglier because not only are they politicized, not only do we have this partisan polarization, but the number of votes that the justices get by the senators who are not representing very many people makes it even more obvious how disconnected the justices are from the electorate.
The Supreme Court is the final arbiter. They're the ones that ultimately decide if something is constitutional or not. And that's, the power of judicial review. And this is also, and I think you might have popped the balloon on this in the first few minutes, but I've always been fascinated with this idea of judicial review, which is essentially a power that the court just gave to itself. And, we've established it as a norm that they can determine what's constitutional, what's unconstitutional, and that, the other institutions simply abide by that. I've heard powerful arguments on both sides of this, but is it time to revisit curbing or eliminating that?
Yeah, I don't know. I mean, somebody has to make the decision, right? I mean, in George Bush's words, someone needs to be the decider. And I don't know. I mean, I feel like sometimes it's better to have an independent institution be that decider rather than an institution that is accountable to the public, especially when minority rights are at stake. But, going back to my earlier balloon popping, that only works if we have people on the court that are interested in protecting minority rights. And we know that they're going to be driven by their ideology. We know that their selection was driven by ideology, that there are certain expectations about their behavior, which are generally upheld when we look empirically at their voting. And so, why the court versus some other body is becoming less and less clear, I think. I think someone needs to have that ability to question. I think checks and balances are very important. And I think that became even more clear when we had Trump in office, who was interested in flouting all kinds of norms. We need that separation of powers. We need those checks and balances. But, is it that this is an exclusive power that the Supreme Court could wield, or could some other body wield it? I don't know. That's kind of an interesting question. What does the research that you read say would be a better body to handle those things?
I haven't come across anything that says there is a better body. I guess I'm just referencing the arguments for or against.
Yeah, I mean, there's arguments about senators also take an oath to uphold the Constitution, and so do members of the House, and so do all
and the president,
and all the state, lots of state legislators have oaths like that too. But I do think you need to establish some sort of, interpretation of the words that is going to be a little bit more consistent than not. So even if the Supreme Court's overturning precedent, there's at least some common law expectation that you can rely on what they said, at least for a few years until there's a change in membership.
I mean, but even that is somewhat normative, I suppose, in that, going back to the early argument that this is all made up, is, this is an actual example of it, right? And it doesn't seem like it's too far-fetched to imagine that someone like, a Donald Trump, or I don't know, even maybe Mitch McConnell at some point getting to the point where they're, like, what, we just disagree with the court, and in our capacities, we're not going to enforce that.
Right. And I think there's a long literature about, so a lot of the comparative judicial literature is based on this idea that the public would protect the power of the court to some degree, that the public would fight back at a McConnell who was trying to change the jurisdiction of the court or something. But lately, like new surveys, new evidence, again, I think because of partisan polarization, suggests that isn't quite true, that people would not protect the court at all odds. Instead, they'll protect the court if it suits their outcomes that they want, and they'll talk about change if it doesn't. And so when you see, the Democratic Party talking about packing the courts or talking about term limits or something like that, that probably wouldn't have happened in a situation where they were winning, right? So I don't think that there's, I don't think that there's anything magical about the jurisdiction of the court, and I don't think that it's unfathomable that a politician might try to curb the power of the institution. And maybe you think that's okay, depending on how you feel about the court.
One way to do that without completely flouting a norm would just be to limit their jurisdiction, which is a power of Congress.
Sure. So is the size, right? I mean, those are things,
right.
both things left to Congress and that have changed over time. But those would be politically motivated, I'm sure, right? I mean, there's no legal basis to say the court can't make decisions about abortion, for example.
Right. Yet. There have been a lot of calls, particularly on the left as of late, to fix the court. Mm-hmm. And that's that's where you're going with this, like limiting time justices could serve on the bench, or limiting their jurisdiction, or expanding the court. What are your thoughts on this generally, altering the court? Do any of these appeal to you, or do any of them seem kind of egregiously wrong?
I bristle at them generally. Because I think that, I probably hold the court in more institutional esteem than other people might. Mm-hmm. So the idea of changing the jurisdiction of the court, the size of the court, the term limits on the court makes me uncomfortable, because I think that there's a real value in a democratic system for an independent branch of government that can make sure that the other branches are respecting the rights of minorities, given that the rest of the process is all about the majority. But, that gets harder to justify when the justices make decisions in the ways that they're making them. Because if the justices are just 9 politicians, then I think there's no reason why we shouldn't have more than 9. And probably no reason that we shouldn't have limits so that more presidents get more opportunities to shape the membership of the court. But I mean, I think, I don't know, I bristle at it because I love the Supreme Court. So I think that, yes, we're already messing with them and have politicized the court, and the court has done its own job of politicizing itself, and that's all problematic. But maybe I still ascribe a little bit to that mythology. I'm not sure.
I've been particularly interested in, the Supreme Court's kind of approval rating, and, compared against something like Congress and the presidency, the Supreme Court has enjoyed, much higher approval rating than the other 2 branches, which have, been underwater for quite a while and, sinking fast. But also the Supreme Court's approval rating is now sinking. I think the latest I read was at 54%. Mm-hmm. And this is me being maybe histrionic, but there is an argument to be made that if all 3 branches of your government are underwater, like, you are creating a potential environment for revolution, for some type of disunion. And if that's the direction the Supreme Court is heading in, 1, I mean, do you agree with, let's say I'm making this argument, do you agree with it? But 2, what are your thoughts about it?
I think that's a really difficult question. And it's one that, I have struggled with as a person interested in legitimacy as well. It's absolutely the case that by any metric, the court's approval has gone down. There are more people that are less protective of the court as an institution. So more people would agree with that statement that we should do away with the court. Fewer people are providing, responses that suggest that we ought to be somehow protective of the independence of the court versus its accountability. So it's certainly the case that it's losing its special nature, and that might be because of its behavior. It might be because of a clearer understanding by the public of what the court is doing, what the justices are doing. And it contributes to a really dire picture when you look at Congress and the president, which are also far less liked. I don't know what that means. So I think, posing the question of, what's holding us together, like I think you said at some point that you used to tell people that it was the Supreme Court holding us together or something, because its legitimacy was always higher and people trusted the outcomes that came from the court. So if we don't have that, what do we have? And I don't know the answer to that. I feel like you should talk to a political theorist or something. Like, I mean, we have what? We have freedom. We have relative security. We have comfort. We have American exceptionalism. Like, does that hold us together? What makes a person decide that they're okay with government decisions? If those democratic values are eroding, at least in terms of their applicability to situations beyond partisan preferences, then I don't know what we have anymore. What do you think?
I don't know either. That's why I'm asking you.
What are we going to do, Shawn?
I for years, I hung my hat on the Supreme Court.
Why did you do that?
I don't know. I was young and stupid.
No, that can't be. Like, there must have been something different at that time that allowed you comfort in hanging your hat on the court.
I came up in a time, and you did too, wherein the court was seen as, the protector of rights. It was slow in plotting at times, but it was generally moving in that direction. And I think we very quickly are beginning to see, or fearing that we're beginning to see, a reversal of that. And I don't know what that portends. I don't know what that means, which I guess leads me to this question. And I'm asking you to prognosticate. So fair if you're not quite sure, but what does a post-Roe country look like? And I'm talking about constitutional and legal landscape here.
Oh, I'm not sure what the consequences would be beyond the immediate obvious ones, right? So, obviously it doesn't make abortion illegal. It just limits the extent to which it's protected by the Constitution. And so states are going to do their thing, and there's going to be, all kinds of battles in the states, right? About travel from one state to another, and telehealth and prescriptions. And I mean, it's going to create a huge debacle, right? That will have to work itself through the court, and there'll be definitions and lines drawn and all those kinds of things. So like that, I think, is kind of an obvious effect. Whether it portends bigger effects for, I think, substantive due process in general is, sort of an open question. I mean, there are definitely justices on the court who hate substantive due process. They hate this idea that the 14th Amendment's due process clause does anything other than giving you procedural fairness, right? And so anything that relies on that is open to discussion. I mean, Alito's draft is, in 2 or 3 different places says this is just about abortion because this is a really morally charged issue and there's a loss of life involved. So it doesn't apply to anything else. Well, again, I think that is, unbelievable, right?
He also, he appends a paragraph in there, that is like a throwaway paragraph where he kind of does set the stage for, and yet there are other things that we don't really have any legal foundation for, Right. And
I think that is his position. And that was Scalia's position too, that, if you want these rights, then you petition your government and you get them to write them down. And these rights are not in the Constitution. We are not here to talk about things that aren't in the Constitution. And, there's some, I understand that argument. But on the other hand, I think it's really hard for anybody to imagine that we don't have the right to do our own thing with our bodies in ways that don't hurt anybody else that's living and breathing, right? It's hard to believe that we would, for example, treat a law that mandated that a man donate a kidney to a child in need if they're a match. Like, people will go crazy about that, right? Like, you can't make me donate my kidney, but you can make me carry a pregnancy? Like, it just seems unbelievable to me that we wouldn't have some recognition in our founding documents when we talk about liberty, or when we talk about, the right to be let alone, or, in the search and seizure cases, in the free speech cases, and all the, we sort of all kind of make fun of the penumbra of privacy that comes out of Griswold versus Connecticut. Mm-hmm. But I think that makes sense, right? There are things that emanate from the way our government was created and the beliefs that we had as a people that seem to suggest that there are certain things that are just off limits to the government. And so if the Roe decision comes down this way and says that abortion is not in that realm, then that has to have implications for other things that people think have to be in that realm, right? Mm-hmm. I don't know.
Okay, right turn. No pun intended. So what is something you've been reading, watching, doing, or listening to lately that is of interest to you, and it doesn't have to be related to this topic?
So honestly, I have been binge watching The Handmaid's Tale.
Oh no, have you really?
And that, kind of is related to this.
Yeah.
Yeah. I mean, I had started it a long time ago and, was appalled and fascinated. And then I just needed a really long break from it because it was I think, when did that come out? Several years ago. So I think it was during the Trump presidency. It was hitting too close to home. And then now with this Roe thing, I was like, now I feel like I have to watch it. Mm-hmm. But I've been doing that. And then, in the summer, I always read a whole bunch of novels, but I haven't really started that too much. I have a lot of research to do this summer on actually legitimacy. So I've been reading a lot of legitimacy stuff. We're trying to figure out if the justices' appearances have any effect on the perceptions of the court, and also whether they make appearances in attempts to change the way people feel about the court. So that's kind of a big project that we're embarking on. I've been reading a lot and doing a lot of searching on those kinds of issues. So, and then running kids all over the place, and my daughter's graduating and everything's changing. And
oh, is she? Congratulations.
She is. Yeah.
What's her plan?
She's going to go to the University of Minnesota, and guess what she's going to major in, Shawn?
Political science?
Yeah, she is. Political science. Isn't that crazy? Yeah.
And now's a good time to be doing it. I have two thoughts. One is, I suppose the feedback you have to give her at this point is, it's all fake. Enjoy your time. And the second thought I have, and this is ancillary, lobbyists are the group I cannot get to agree to chat with me.
Really? Oh, yeah. I have a contact for you. I'll send you an email.
Yeah, do that.
He's older, like he's at the end of his career, so he might be interested in kind of looking back.
Rewriting history.
He did tell me before I even met him on a email conversation that he was a never Trumper.
I feel like never Trumpers lead with that. Just an FYI.
I did not ask you. I'm happy to have you come and talk to my students. I don't care what party you belong to or any of that kind of stuff. Yeah. But he definitely wanted me to know that.
Okay, Dr. Benesh, thank you. I really appreciated this conversation.
It was a lot of fun, but it was really those questions were super hard. So
I feel like we're gonna be confronting those, I think, as a matter of course moving forward.
Yeah, I think there's a lot of big problems in our country right now, and I don't know. I mean, I'm just hopeful that this younger generation is going to fix them.
Yeah, well,
no pressure, but boy, we got a lot of stuff to fix.
Okay, thank you.
You're welcome. Anytime.
There you have it. For the most part, we agree. The court is in a transformational stage, and it's consequential. And that suggests that the country itself may be facing some significant restructuring of how we understand and access our rights. It remains to be seen, as a result, and here I'll oversimplify some thoughts expressed by the two of us, if, 1, the country begins to pull apart at the seams, begins to fray, if it is pulled to its knees, as I suggest, or 2, as maybe Dr. Benesh suggests, if the states will simply take a more active role in crafting policy, much more regionally, making the states more fertile ground for policy activism in a way that might create a disparate patchwork across the country of rights we have conceptualized as fundamental. Or maybe we'll kind of see a mix of both. We'll know more over the next couple of weeks as the court starts to release its opinions on some of its most controversial cases this term. And I may revisit this later in the season. Premiere Week continues this Friday when I shift gears and focus on secession, its history in the United States, and maybe its future. This is a two-parter over 2 episodes, so this Friday I'm focusing on the past. I'll be speaking with Dr. Susan Schulten out of the University of Denver, a historian and Civil War expert, about those things that mattered in the run-up to the Civil War and what lessons can be derived. The following Friday, I focus on secession movements today and what they might suggest for any imminent breakup of the states. I'll be talking to Dr. Timothy Waters of the Maurer School of Law at Indiana University and Marcus Ruiz Evans, the leader of California's Cal-Exit movement. In the meantime, if you have any thoughts, questions, or comments, please feel free to write me at deepdivewithshawn@gmail.com. Chat soon, folks.